So by popular demand, I'm going to talk more about private placement memorandums today. Let me share my screen. Pretty common questions that we get has to do with private placement memorandums. Okay, so what are they? And, do I need one? What exactly does it do? So the first, overlying topic is legal issues and raising capital. Because anytime you have a private placement memorandum, usually it has something to do with going out to investors and raising money. So there's different legal issues that come up in raising capital under the 33 Act, which is securities registration, the Exchange Act, two different sections of the Exchange Act, Investment Advisors Act, Investment Company Act, and that's just general corporate tax and state law compliance. These are all things that an attorney needs to think through when they're helping you, structure going out to raise capital from investors. So it's not simply downloading a template that you get online of a PPM, which is what they're commonly referred to for a private placement memorandum. There's a lot more that goes into it that your attorney needs to think about. So a private placement memorandum, what is it? It's basically an offering document. It's a disclosure. So if you buy stock in a publicly traded company, every quarter in the mail or by email, they'll send you a prospectus. Usually a prospectus talks about the company and what they're doing and risks of investing. It's kind of the same type of thing. And basically for a private company, in some cases, you need to disclose to your investors the risks of investing. I'll go through a list of the topics that are commonly covered. But when you go out to raise capital, depending on the type of securities exemption that you're relying on, you may be required to present one to your investors with enough time prior for them to read it before investing. So we commonly put these together for clients and they give them to their investors prior to signing a subscription agreement. So you'll see templates of these online. I'm going to show you kind of a sample of one just from a general limited partnership. But some of the common areas or topics that are covered: an executive summary, kind of, why are we raising money, who we are, what are the risk factors, and any SEC disclosures. These are usually going to be in all capital letters or bold, just, basically about any kind of securities law issues that need to be disclosed. Background of the company, basically who are we, and, who the company is, what's the structure, who are the owners, who's the management, who's in control of this company, and a business plan, basically saying, what are we planning to do? What are we selling? Is it some type of service or a good? What type of industry are we in? Who was the competition that we're going to be going up against? What's our sales and marketing plan, operations plan, hiring plan? Not all PPMs go into that much detail, but it is recommended that you go into some of these specific areas. Financial projections. If you're going out to investors, you're telling them, you put X number of dollars in, and here's your 3 times return, and here's how we've projected it out in 5 years, or whatever the case is. The terms of the offering, and what that means is you are offering to basically to your investors, invest with me, and you're going to get 10 shares of stock or 10% of my company, Shark Tank. Okay, for $100,000, you can have 5% of my company. That's the terms of the offering. What are you offering to your investors? What do they get? Normally, you want to cover the source and use of funds. So if I raise $1 million and I'm bringing it in from investors, what am I using it for? Is it going to go towards working capital? Am I buying some piece of machinery? And finally, what's the exit strategy? So as an investor, you want a general idea: when can I get my money back or get a return, or how am I going to see a profit on this? So let me switch screens and show the other one that shows a sample. All right, so I've blacked out some names to protect the innocent or guilty. So basically, I think this is from a few years ago, a fund that I did, this is not, like you don't look at this and say, okay, everything in here has to be in a ppm. This is just kind of a sample of what you would see if more of an attorney drafted ppm. So usually the securities disclosures about confidentiality and whether these securities have been reviewed by the SEC or a state securities agency. So these are the kind of disclosures that you'll see up front usually. There might be notices to specific investors in certain states that might be required by securities law. And then you start getting into the meat of it. So basically the terms, okay, partnership, here's the company. Here's who we are. Here's when we were formed. Here's who is in charge of us as either a manager or how we came to be. Under here, it says investment program. What's the objective of you investing in us? Here's what we're going to do. This is our business plan. The offering is we're giving, we're selling limited partnership interests. You have to put in at least $100,000 to be able to participate. Non-transferable. You cannot go around and basically buy limited partnership units and then turn around and sell them to someone else. This talks about who the general partner of the entity is, basically who's in control. And it talks about the management team later. The term of the company, who can invest. So is this for, this one looks like it was accredited investors only under Reg D, which these days would be a 506B or C. You can do accredited only under B if you wanted to, or C. How long are we offering this? Up to 99 beneficial owners. So this is an Investment Company Act issue under 3C1 that they're keeping it at 100 investors or less to qualify for that exemption to avoid registration as an investment company. Here again, here's the minimum contribution, $100,000 minimum to invest. Whether you have to put in additional capital later on. So can the general partner basically come to you as an investor and say, I know you put $100,000 in, but you need to put more in. And usually it'll be disclosed whether you're required to or not. Taxation, how the company is taxed, more tax-related issues. What are the fees? This is a big one that really needs to be disclosed, even in a private context, not just publicly traded companies. What are the fees that are going to be taken out? So the management fees, any compensation of the top people at the company should be disclosed so your investors know where their money is going, that somebody at the top isn't making some outrageous salary or some huge fee that you don't know about. And that might change your decision on whether you would invest or not. If the CEO is taking a $5 million salary a year and it's a brand new company, you might have an issue with putting money into something like that. So that should always be disclosed. Withdrawal. So this covers issues of, okay, when can I withdraw my capital? And here it looks like you have a 3-year holding period where you're locked up. You cannot get your money back out until at least 3 years later. So some funds, you can get your money back right away. Sometimes they're planning on selling an asset and paying you off in a year. Here, it's saying you have to hold at least 3 years before you could potentially get your money back. And again, these are some risk factors, disclosure of conflict of interest. Okay, there's a conflict of interest because the general partner owns a management company that could be getting some fees, and the management company owns the general partner, or whatever the case is. And talking about when reports are given to investors, how to subscribe or invest in the basically the fund or investment. What are the proceeds being used for? And this gives a little bit more detail of prior performance of this fund. It looks like this was a limited partner fund that was investing in notes, promissory notes. And it just talks a little bit about how the companies run, their prior performance, and some of their policies, their competition, the industry that they're in. Here, this talks a little bit about why people would use this service that they are basically providing to people. This is all blacked out because this is confidential to a client, so we can't disclose it. But this just basically goes a little bit over all of the different areas that I discussed earlier. Here's the management, the people who are on the board or managers, executive officers, a little bit about their background, their bios, sort of who they are. What the offering is, 12% notes that are being offered, a little bit more about the partnership. So if you can see, let me go back up here real quick. Up here, most PPMs will have a summary of the terms or summary of the offering. A lot of times it's in a table format. That's pretty common. And this goes over the main material terms of the fund, the offering, the company, whatever it is. And then outside of here, these same categories might have more detail further down in the private placement memorandum. So it gives a little bit more details on the specifics of the background of the company and management. Investor suitability. This means, okay, who's allowed to invest in this? Are you the right type of investor for this? Are you accredited, or whatever the specifics are? This one's accredited only. And here's a list of some of the different definitions of accredited. And there are also certain disclosures for restrictions, basically sort of anti-money laundering restrictions that need to be complied with. This is more tax stuff, fees. So again, you can see that they're just giving a little bit more detail about the specific business beyond just the summary of the main terms. And some of this is like a business plan, like, okay, here are some of the common categories that we feel we should cover to properly inform you about our business. So here's some of the risks: different limited liquidity, conflict of interest, natural disasters, other specific risks that basically, if you put your money in, here are some potential risks of how you could lose your money, whether it's related to the company, the structure, the economy, whatever it is. Usually we want to disclose all of the potential risks. Now, why is all this disclosed? In some cases, it's required by the SEC. In some cases, it's not necessarily required, but if you go to any larger investor or their counsel, they're usually going to say, where's the PPM? Like, where's the disclosure document, offering memorandum, whatever they want to call it, that tells me about this deal so that I know all the specific terms. And that's what the PPM is. It also serves as a protection in court. So down the road, investor Y sues you because he says, you know, hey, you never told me I was going to lose my money because you were investing, you know, potentially 10% into this other business, or you were going to take your operations from the US and start manufacturing in Mexico. You didn't disclose that to me. You knew it when you took my money. You should have disclosed it. So now I'm suing you for all different types of claims, whatever they bring. Then in court, you can say, look, I've got your signature on this PPM that was provided to you before you decided to invest. So now you can say, hey, how can you say you were not fully informed when I've got a 97-page document that I have proof you received before you decided to invest? And on page, whatever it is, 51, we disclose the risk of potentially investing and that our operations could be moved out of the US or whatever the issue is. So, this helps protect the people putting the deal together as well, even if, whether on a federal or state level, it may or may not be required. In some cases, it's not necessarily required that you provide these, but it's always a good idea. So that's just a little bit about, this goes into more tax specific issues that are disclosed to investors. So again, most of this is blacked out. but I'm just trying to give you a general idea of kind of what these look like. And this was information on how to subscribe, basically how to invest. So that's just a quick overview of what a private placement memorandum is, what a sample one looks like. Again, they can take all different shapes and sizes and forms, but it is always a best practice to have one in place when you're out raising capital, whether you're raising $1,000 or $100 million, it doesn't matter. From a regulator's perspective, you're still raising money from an investor, and they want to make sure that they're fully informed. Again, thanks for watching, and we'll see you soon.